Hello, my name is Ross Soltis. I'm a lawyer in New York City. I made this video to help New York City landlords in a situation when you have a tenant who is not paying rent. I know from experience many landlords, before they start a court case against a tenant, they would like to know how much time the whole process is going to take, so I tried to answer that question in my video. And also I explained the legal process a little bit.
Speaking about the legal process, before landlord can start a court case against the tenant, landlord has to give to tenant 3 notices. So at the beginning of this video, I explain about these notices and how they should be delivered to the tenant. After that, if tenant received the notices but tenant still not paying rent, landlord has to come to court and file a document called a petition. And also a copy of the petition has to be delivered to the tenant. And the petition tells the tenant that a court case has been started against the tenant and tells the tenant to come to court. And after that, there could be 2 possible scenarios. Either tenant comes to court, or sometimes tenants just ignore the petition, ignore the legal process, and they don't do anything. So in this video, I explain both scenarios, and I give an approximate time estimate, how much time it may take for the landlord to get the case resolved. A couple of housekeeping items before we start. The information in this video is applicable to all of New York City, except for certain time periods. And this is because certain time periods I will be discussing in this video are specific to Brooklyn only. But each time I mention something which is specific only to Brooklyn, I will specifically say so. This presentation is not legal advice. It's just general information about the court system. If you have a court case or if you think about starting a court case, you need to get a lawyer. If you have a question about anything said in this video or in general any question about landlord-tenant law in New York, do not write your question in the comments below, but call me or email me. My numbers are on top of this slide. Also at the end of this video, I'll be happy to help. And also there is much more information about landlord-tenant law in New York on my website. You are very welcome to check it out. This video is specifically about the problem when a tenant is not paying rent. And it also explains how a landlord can start a court case against the tenant for non-payment of rent. This video does not cover other problems landlord may have with a tenant. For example, when tenant is staying in the apartment after expiration of the lease, tenant is damaging the apartment, or other types of situations. This video is specifically about a non-payment of rent situation. Now, when landlord starts a court case against tenant for non-payment of rent, the official legal name of this type of court cases is non-payment summary proceeding. To explain in very simple words what non-payment summary proceeding is, I would say it follows this principle: as long as you pay, you stay. It means that if tenant comes to court and tenant is able to pay the outstanding back rent, it's also called rent arrears. So if tenant is able to pay the rent arrears, tenant would be allowed to stay in the apartment, basically to continue to live in the same apartment. And only if tenant is not able to pay the rent arrears, only in this case, landlord can ask the judge to issue an eviction order, eviction judgment, and tenant will be evicted from the apartment. So once again, to make it clear, if tenant is able to pay the rent arrears, there is no eviction. And here is an important difference between a non-payment proceeding and another type of proceeding, which is quite common in New York City Housing Court, and which is a holdover proceeding. And in a holdover proceeding, landlord wants to evict a tenant for a reason which is not related to non-payment of rent. A good example can be, for example, an illegal sublet when tenant is subletting the apartment in violation of the lease, a tenant doing something illegal in the apartment, or other like situations. And quite often landlords start holdover cases against tenants who are fully current on all rent payments, because the reason for a holdover case is not related to non-payment of rent. So this to understand the difference between a non-payment summary proceeding and a holdover proceeding. But once again, this video is not about holdover. This video is about a non-payment of rent situation. Now, before landlord can start a court case against the tenant for non-payment of rent, the law requires the landlord to give to tenant 3 notices. These notices are the 5-day notice, the 14-day notice, and the good cause eviction law notice. The good cause eviction law notice is not a separate notice. It must be attached to the 14-day notice. Now, a 5-day notice is more like a reminder to the tenant. It tells the tenant, your rent is past due, please pay. But the 14-day notice is more like a formal warning to the tenant. It tells the tenant, we give you 14 days to pay. If you do not pay, we go to court. Now, a good cause eviction law notice tells the tenant whether that particular apartment is protected under a New York State good cause eviction law. And now a couple of words about good cause eviction law. It applies mainly to landlords who own 10 and more apartments in New York State. And good cause eviction law does 2 things. Firstly, it limits rent increases, annual rent increases. Currently, the limit is set at 8.7%. And if landlord wants to increase the rent over 8.7%, landlord must provide or show a good cause why that good cause means a good reason why the rent should be increased over a set limit. And secondly, good cause eviction law prohibits lease terminations without a good cause. How it works is that law provides a list of reasons when landlord is allowed to terminate the lease. Those reasons are considered to be good reasons, good cause by the law, and a landlord is allowed to terminate the lease only for those reasons that are listed in the law. Now, as I said, those 3 notices, 5-day, 14, and good cause eviction law notice, those 3 notices are mandatory. That means that landlord cannot start a case in court unless all 3 notices have been delivered to the tenant. And also there are specific rules what kind of formal legal language must be included into each notice. Those notices cannot be sent by email, cannot be text messages, must be formal paper notice, and must be delivered to the tenant. Regarding delivery, there is a special legal term called service. Service basically means delivery of a legal notice to a person. So there are specific service rules regarding how each of those notices must be delivered to the tenant. For example, the 5-day notice must be mailed by certified mail, but the 14-day notice, if possible, must be delivered to the tenant personally. And there are specific rules what to do in a situation when it is not possible to deliver the 14-day notice to the tenant personally. On my website, there is a full explanation how all the service rules work in details in different situations. I just wanted to mention here that a landlord cannot do a service himself. That is to say, landlord cannot deliver any of those notices to the tenant himself. Usually, landlords would hire a professional service. which is called a professional process server, and the service will perform the delivery of those notices to the tenant. Now, to summarize this slide, when a 5-day notice has been delivered or has been served upon a tenant, and 5 days go by, 14-day notice has been served on the tenant, 14 days go by, and there is still no payment of rent. In this case, or in this situation, landlord is allowed to start a legal case in court against the tenant for non-payment of rent.